First appeal on our calendar today is the state of Maika. Counsel, whenever you're ready.
Good afternoon, Your Honors. I'm Mary DiAugustino from Hancock Estabrook, and I'm here on behalf of Petitioner Appellant. If I may, I'd like to reserve 2 minutes for rebuttal, please.
You have 2 minutes.
Thank you. If the court permits the appellate division decision to stand, then the conveyance will have escaped the heightened forms of scrutiny and presumptions that typically apply when an attorney in fact engages in self-dealing and when services are rendered to family members of the same household. The decision below should be reversed for the reasons stated in the dissenting opinion for the following 3 reasons.
Doesn't the
First,
fact that there was a majority of people and not just one diffuse that argument?
I disagree with that, Your Honor. Yes, there was a majority of people that voted in terms of this committee, the committee that was permitted to act under the power of attorney, but the deciding vote was someone that was interested in the outcome of the decision. So setting his vote aside, there isn't a majority. You have the 2 individuals that voted for the conveyance, you have 1 individual that voted against the conveyance, and then you have someone that's interested in the outcome. The very fact that his
Sorry, was the person who voted against the conveyance a person who was authorized to vote? Did they have the power of attorney that allowed them to do that?
Yes, that's correct. Originally, there were 5 individuals under the power of attorney. 1 of them resigned, so that left 4 individuals under the power of attorney.
Aren't they all interested?
To a certain extent, because
They would inherit if the transfer weren't made, so.
correct. So you have two individuals that, by voting to convey the property at issue here, that they would take less in the event that, on the decedent's death, correct. So to a certain extent, they were interested. And that
What
seems to...
about the best interest of the decedent? Do the attorneys, in fact, have the authority to do that which was in the best interest of the decedent?
They did. But they were also the fiduciary for the decedent. So they had an obligation under the power of attorney to act in the best interest of his financial, estate, and tax plans.
What about the fact that he didn't want to go into a nursing home?
I don't think that's necessarily clear on the record, Your Honor. There were conversations...
So could the case go back for a hearing on the best interest aspect of it because it was not done before?
At worst, I think there is a question of fact here, but I'd submit to you that on this record right here, simply that respondents didn't meet their burden of proof by clear and convincing evidence to demonstrate that...
How would respondents meet their burden of proof in a scenario like this one where the principal, I believe, was incapable of speech, right?
That's my understanding, correct.
So the only thing you really have to go on are the attorneys and facts, recollections or representations about what the principal actually wanted.
To a certain extent, Your Honor, I think what's clear on the record is at the time of this conveyance, the decedent was in the terminal period of his life, and at least at that point, he couldn't express his intent. But beyond that, I don't know what happened between 2009, when the mother died, and when this particular conveyance happened in 2017. And yes, there are those conversations between the attorney and fact, but the other thing that you have in this record is the decedent's will from the 1970s, which expressed that he wanted his entire estate to be divided among his 12 children.
Is that will in the record?
Yes, it is, Your Honor.
It wasn't probated, though, that will, right?
Correct, because they weren't able to locate the original will. So only the copy is in there, but at this point on this record, that's the best evidence of the decedent's intent was this
But
will.
things change. His circumstances changed.
Sure, they can, but we'd be speculating what he wanted in the terminal years of his life on this record.
Although you may speculate as to what he may have wanted, but the question of his best interest is always something that is the responsibility of the attorneys, in fact, correct?
Yes, I would agree with that. And the assumption seems to have been made here that the best interest of the decedent was that he avoid a nursing home. And you're right, circumstances changed. Maybe there was a situation at the end of his life where that wasn't in his best interest. Maybe the nursing home wasn't his best interest.
So you're saying there isn't a question of fact, but at worst, if you don't get your way, they're not entitled to summary judgment.
Yes, Your Honor, that's correct.
You haven't
Even
moved-
if they're, even if, what do you say the question of whether or not he wanted, or he did not want to be in a nursing home, which it seems that was his intent, he didn't want to be in a nursing home. Isn't there a minimum along the same lines about question of fact, whether or not that goal could have been accomplished in a different way, that is to say, somehow putting another mortgage on the house, there would have been some other way, or bringing other people to care for him to achieve that goal without transferring the property to two of the children who were caring for him.
Correct, and I think that goes back to the best interest inquiry. So for example, they've had this power of attorney for 7 years. There wasn't any Medicaid planning that was done. There wasn't any inquiry, or there doesn't seem to have been any inquiry toward the end of his life, whether someone else could have been brought in. There seems to have been some cursory discussions about a reverse mortgage, but on this record, we can't determine if this was actually in the best interest.
Is there anything in the record to clarify his intent with respect to whether or not he only wanted family to care for him versus an outsider?
I don't believe so, Your Honor. And even with respect to his intent, that's even less clear because the conversations occurred between the attorneys. In fact,
Yes.
it occurred between the siblings and the mother. And I don't know his mental state at the time these conversations occurred. It's not clear on the record, but I don't think you can discern that from this record before the court.
You didn't move for summary judgment below, so I don't believe we can do anything other than vacate the grant of summary judgment and then send it back. You agree with that?
I would agree with that, Your Honor.
So you're sort of left with the question of fact that you've got to argue before somebody else whether there is or isn't one, and then what it is.
Correct. I mean, the surrogate did search the record and determined that we met our burden of proof in terms of summary judgment, but I understand that your hands are tied in that respect. And like I said, at best, at worst, I think there's a question of fact here.
Counsel, how do we review their determination, these attorneys, in fact? How do we review their determination that this was in the best interest of the principal?
I don't think that you can on this record. There's simply not enough information here.
I guess my question would be, a court, even if this went back, are they looking at now, and we look at Medicare, and we look at this, and we look at that, and we think, was that decision really in the best interest? Or do we look at, given what they knew and that they were looking at the time, can we say as a matter of law that that wasn't in the principal's best interest? How do we review it?
I mean, this may be a failure of burden of proof in terms of respondents and whether they'll be able to demonstrate whether that this transfer and conveyance was in the best interest of the decedent.
But isn't the standard really that they believed it was?
Well, I think that's where the Fourth Department disagreed and where there's a dissenting opinion. The majority opinion seemed to say that it was the intent of the attorneys, in fact, to act in the best interest, whereas the dissent said that it was the intent of the parent, the intent of the decedent, and whether it was...
But it seems like the whole purpose of this arrangement is to get away from the intent of the decedent, right? I mean, you're offshoring that decision in a limited set of circumstances, but why would you look back at the principal's intention if the principal has signed away the ability to make that decision in these circumstances?
Well, I think that goes back to perhaps the will. And again, it wasn't probated because they couldn't find the original. That is really the only expression of his intent and what he wanted to do in terms of
The
his
expression of
estate.
his intent is the power of attorney, because his intent was to give them the authority to make contracts, right?
Correct. And I think that perhaps goes back to the love and affection and the reason that these individuals were caring for their parents. That in and of itself creates a presumption that they were rendering these services for love and affection, not for compensation.
I'm sorry, can I ask you, does the statement of intent in the will include some sort of presumption that the principals, that the attorneys, in fact, will preserve the estate? Is that just an accepted axiom of a fiduciary relationship?
I don't believe so, Your Honor.
So that leads me to ask, why would, similar to what Judge Garcia just asked, why couldn't the principals decide what they believed was in, the attorneys decide what they believed was in the principal's best interest at the time and dispose of assets prior to death?
Because I don't think there's enough information here for you to determine that this was in the best interest of the decedent. There's simply not enough information on this record to make that determination. And, in the other cases cited, these other appellate division cases, you have situations where the decedent was present when the conveyances were made. You have situations where the decedent was well aware that these conveyances were being made. Here you have an individual that was in the terminal months of his life that doesn't even seem to have been aware that this conveyance was made. So it's difficult to conclude when the property owner, the decedent, wasn't even aware that this conveyance was occurring, that this was in his best interest.
But I'm not sure why that matters to you. Let me try Judge Garcia's question from the other direction. If there were no conflict of interest, right, so they're all disinterested trustees, right, and if there were no restriction on the ability to give gifts, I'm not sure you would be here arguing about the intent of the now decedent, right? Because he's delegated, not exclusively, but he's delegated to this group the power to transfer his assets. There's no conflict, and it's not a gift, so it's within their powers. We wouldn't care what his intent was, would we?
Well, even the attorneys, in fact, disagreed over whether this was in their best interest. You have one that voted against this conveyance, and then
Yeah, but if there had been a real majority, right, and the instrument says a majority can decide, would you be here arguing about what his intent is? I mean, as I understood it, your two arguments really were the conflict and the restriction on gifts. And whether this is a gift or not that's somewhere where the intent figures in.
Correct. So if intent doesn't matter, then you're back to whether the attorneys, in fact, were acting in the best interest of the decedent, meaning...
But this is sort of Judge Garcia's question, I think, which is if you take out those other two things, right, the restriction on gifts and the conflict, do we really look behind, let's say it was a unanimous vote, would we be looking behind that to ask about the decedent's intent?
Perhaps not with a unanimous vote, but you don't have a unanimous vote here. At least in terms of the attorneys, in fact, there was a question from them whether they were acting with the utmost good faith, moral fidelity that's required when someone is given a power of attorney, when someone is acting as an attorney, in fact.
So the rule would be, even if an instrument says majority vote, if there's a dissent, then you would apply a different standard of scrutiny than if it was unanimous.
Well, the issue here is Philip, because
Because of
Philip...
the conflict, I understand that.
Correct.
I'm trying to put that aside for a minute.
So putting Philip aside, though, then you don't have a majority of attorneys, in fact, acting on behalf of the decedent.
Right, I'm asking about a hypothetical rather than this particular case. I just wanted, as I understood your argument from the papers, and maybe I misunderstood it, you had two problems, really. One was that this might be characterized as a gift, and if it's characterized as a gift, then the group does not have the power to make this transfer.
Correct.
That's one argument.
Yes.
The other is that aside, because Philip is interested, he can't really participate in that, either completely voids whatever the group did, or at least it takes his vote out of it and there's no majority, and therefore
Correct.
those are the two arguments you're making, I think.
Yes, that's correct.
So where is intent relevant then? Which one of those two arguments and why?
It seems to come into play, give me just a minute, Your Honor,
Sure.
I'm sorry. It seems to come in with respect to the fact that there's a conflict, and that's what the dissent at the Fourth Department said, that when there's a conflict with one of the attorneys, in fact, benefiting from the transaction, then you have to look at the parent's intent and whether the parent actually intended to compensate for the services rendered.
But it seems like that would be, to follow up on what Judge Wilson was saying, why wouldn't that just be the end of it? I mean, if you don't have enough to vote, there's no transfer.
Because you're still dealing, this isn't someone, a non-party nurse that's rendering services to the decedent. You're still dealing with family members that are living in the same household that are caring for their aging father, and the presumption that arises with that is that they're doing that with love and affection, and that's why I think that you look behind the powers of attorney and look at the intent. Did the decedent intend to compensate his children for caring for him in the last years of his life?
And that's why I thought that's why I guess I was surprised by your answer just a minute ago, because I would have thought the intent would have gone to the question of whether this was a gift. That is, if we had clear evidence that the decedent intended to pay his children for their services, then we would conclude this is not a gift. Okay.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Daniel Rose, Costello, Cooney, and Farron on behalf of the respondents. As I've listened to this discussion so far today, it occurs to me that we're a little bit losing for the forest for the trees. The primary question to address, and which was raised by the dissent, is whether or not this was the self-dealing presumption arises. In my view, if the self-dealing presumption does not arise because only one of these 4 committee members is implicated by the transfer, then we need not inquire as to the intent of
The transfer
decedent.
doesn't happen unless the self-interested individual votes that way.
But if only one of the 4, does that make it a self-dealing? Because the other 3 don't take. They don't benefit from this transaction in any way. So that's the first inquiry. Does the self-dealing presumption arise when only one of the 4 benefits from the
Let me ask you, I
transaction?
guess what is obvious, I take it there is no dispute that you count for majority purposes from the 4, not the 5, because 1 has left. So there's nothing, let me just put it this way. There's nothing in the power of attorney instrument that requires that the majority be measured by the initial individuals who are identified as having this power of attorney.
I believe the language is,
Still left with, you've got to have 3.
But even if you had 4, wouldn't you need 3?
No, that's not the question. The question is whether or not you must always count from 5. I know you're counting from 4 to get you the majority. That's not the question.
the language within the power of attorney states that a majority of my agents must act, okay? So to the extent that 1 has resigned, she's no longer an agent, now you have 4 agents. My read of that language is,
So why doesn't that create an ambiguity that makes summary judgment improper as to whether or not the number is 5? Because if it's 5, it's clearly not going to be a majority, regardless of who you're counting.
Your Honor, if the number is 5 and you need a majority, you have 3, you still have 3. Whether
Yes, but
it's
3 didn't vote in favor.
3 did vote in favor, Your Honor.
I'm sorry.
Including Philip.
I'm sorry, that's the one I'm discounting. Yes.
Right. So the only way that that analysis matters, Your Honor, is if you analogize to a board of directors and discount an interested vote, therefore, as if Philip had abstained, and now you need a majority of the disinterested, right? Then you don't have 3 of the 4, should the 5 apply.
So even under the original 5, if you had 2 plus 1 like you had here, it would have been the same result.
That's right, Your Honor. Now, let's assume, for purposes of argument, that the presumption arises, because if the presumption doesn't arise, we're finished. But if this presumption
I'm
arises,
sorry, why are we finished with the gift issue?
this was not a gift, Your Honor.
Well, but that's the
There's
other
no
arg-
argument by
that's-
respondents that this was a gift.
No?
That if this was a gift, it clearly fails, because there's no gift writer within the power of attorney.
I thought that was the other grounds asserted.
They've asserted it. We've conceded from the trial court on up. This was not a gift. This could not be a gift. This was, in fact, a performed contract. Services were provided, compensation was given. And that's in the affidavits of all of the powers of attorney that are
Isn't
contained.
your adversary arguing that there was no consideration here, and therefore it couldn't be compensation, and therefore it was a gift?
Your Honor, she may argue that. There was 7.5 years of round-the-clock care for this extremely disabled individual.
Right, and the question was whether that was provided gratis or the expectation was for compensation. Isn't that still a live question here?
The question presented by the case law is that there's a presumption that it's done out of love and affection, gratis, as you say, Your Honor, unless you rebut that presumption by showing that there was a contract express or implied for those
So what
services.
establishes that there was a contract to pay
The
for the service?
affidavits of the attorneys in fact, Judge Troutman. The fact that they have attested to the fact that this was in fact a transfer done intended to compensate them for the years of service that they had provided.
And so their affidavits is what is determinative, not the intent of the decedent? Is that your argument?
My argument is that their affidavits established there was a performed contract. The question of the intent of the decedent, I think, is a little bit of a red herring. So we know from the Mantella case.
As to whether there was an intent that he would compensate them, that they were fulfilling his wishes based on the fact that it was always understood that they were to be paid.
So I'm not sure that there's anything in the record, and nor I think is it appropriate to inquire what the decedent's intent was. The record does demonstrate that this was a severely disabled man, incapable of speech, incapable of walking and doing the most basic things on his own. When he was competent, executed a power of attorney that gave this committee the ability to act in his stead. His intent may be relevant in the facts presented in some of the cases like Mantella, or I'm going to mispronounce it, Naumoff, from the Third Department, where there is a single agent transferring property to himself. The question
So
then...
your argument here is there was a contract between the attorneys in fact and the service providers that they would be paid?
That's correct. In his best interest, Your Honor. So the dissent misses their own precedent of Borders versus Borders from 2015, where they recognize that you need to look, when you're questioning, when you have a self-dealing question, you look either to the intent of the decedent, who presumably will always be acting for his own benefit to the extent that he's able, or you would do an analysis of whether this was in the best interest of the principal. In this case,
Is there enough in this record to establish that this was in fact in his best interest?
I think there's nothing in this record but evidence that this was in his best interest, Judge Troutman.
Aren't there questions as to other ways that he could have had this medical care that he needed that was not explored?
What's in this record establishes that if he had gotten outside home care for the period of time that Phil and Ann took care of their father, it would have exceeded $1.5 million. We know that if he had gone into a nursing home under Medicaid, his entire estate would have been depleted.
We only know those things after the fact, though, because there's also testimony in the record, I think, that nobody knew how long he was going to live. They actually expected he was not going to live nearly as long as he did.
That's true. And to the extent that there was an expectation that he may have only lived for a year, there may have been no compensation to Phil and Ann if, in fact, his demise had come much earlier. In fact, Ann raises the question with the attorneys, in fact, after she's been caring for her father for a number of years, and says, this is not sustainable if I'm not getting compensated.
But with respect to the numbers you quoted, isn't there still an issue? Those numbers are about round-the-clock care, which he needed. The record does establish that. I don't think there's a dispute about that. But there might be something short of paying for round-the-clock care that might have addressed this, no? And he might have wanted to compensate them, but not necessarily to cut out the rest of the children from their share of the house.
Perhaps. Then the question becomes...
And one of them was getting $300 a month, which granted, of course, that doesn't come close to the amount that a private caretaker would charge, but that begs the question about what a child might expect as appropriate compensation, and what a parent might be willing to give as appropriate compensation to their own child who's living free in the house.
So I guess I'm not clear on your question, Your Honor, but it seems that the shortage of evidence in the record
I guess
comes...
I'm raising a question about whether or not there are other questions of fact beyond the ones that we've been talking about regarding the compensation itself.
Your Honor, I don't think there are. The appellant didn't introduce hardly any evidence. There's no evidence that this was not in his best interest. What we're here doing is speculating that there might be other evidence, but that's not how summary judgment works.
Should we
What's your burden?
Pardon?
What was the burden of your
Our
part?
burden was to establish that this was not a gift. The petition said this was a gift contrary to the power of attorney, and our response was that this was in fact a contract, fully performed services to take care of their father for this period of
Because
time.
the two caretakers wanted to get compensated and a couple of other people agreed they should?
That's right, Your Honor.
And somebody disagreed.
And one person disagreed, one of the four, that's right.
Should we consider at all the benefit that they received by living in that house rent-free, not paying for utilities? Is that something we should look at?
Your Honor, the cases seem to discuss whether it was a mutually beneficial arrangement. And I think on this record, you conclude that this was not mutually beneficial. They had to live there just like an outside in-home care provider would have to be there during that time.
Except they were living there, particularly in Philip's case, for a very long time before he needed any care.
And that may be true. What occurred?
Well, is it true? It is true, right?
It is true. It is true that Philip
During the
lived there
time that the mother was alive, who was indeed doing most of the caretaking at that time, if not all of it.
He was doing some. I'm not sure the percentage and how much the mother was caring for her husband during that period.
And wasn't there evidence that Anne was kicked out of her other residence and had no choice but to live there?
That's the claim, that's the hearsay claim by one of the other sisters. I would submit that even if Anne had come home for a short period of time, and I believe it also may have coincided when her mother had some sort of injury and was, for that period, short period, unable to care for her husband. But I would submit that Anne would not have been obligated to stay in the house for that long period of time. Even were that true, she would have gone out, found another job, found another home, and not been in a situation where she was caring for her father for 16, 18 hours a day.
She did receive some money during that time.
She received a very small amount of money.
Yes, I agree that in comparison to the amount of work put in, what a private caretaker would request it's a small amount of money, but that, again, we go back to, well, what would have been the compensation for your children to do this? If that was the intent, to compensate. Now, your answer may be, as I think it has been throughout, that only the attorneys, in fact, get to decide what is the proper compensation once you get past the point that it's not a gift, the intent is to compensate.
That's right, Your Honor.
Thank you.
All right, thank you, Your Honors.
Thank you, Your Honors. I just wanted to remind the court of the procedural posture. The respondents were the one that moved for summary judgment, so all of the inferences should be drawn in favor of the petitioner in connection with this because they didn't cross-move. Now, I understand the surrogate did search the record and grant summary judgment in their favor, but those issues that the court just raised in terms of the respondents living in the house rent-free, the respondents not having to pay utilities, all of the inferences that can be drawn from those facts are to be drawn in favor of the petitioners in connection with this matter. And unless the court has any other questions, I'll rest on my papers.
Thank you very much, Counsel.
Thank you.